Iku Iluna. Please rise. Auhea o ko e ko ka aha. Inahe, kuliana imua o kea aha ho o kolo kolo ki eke hano hano o ka moko aina o Hawaii. Inai mai, e malio mai, ilohe ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalu. Please be seated.
Please call the case.
Case number SCWC-18-0000941. William FORESMAN, respondent, versus John FORESMAN, petitioner. Arguing for petitioner John FORESMAN, Scott Brower. Arguing for respondent William FORESMAN, Frederick J. Ahrensmeyer. Argument on the merits.
All right, good morning, aloha to both of our attorneys and everyone watching today. We're being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you ready to proceed? All right. We've allocated 30 minutes for each side. Mr. Brower, you've asked for 20 minutes. Your initial argument reserved 10 minutes for rebuttal, so we'll give you a warning at 20 minutes in. Mr. Ahrensmeyer, we'll give you a warning with 4 minutes to go. That was your request. Mr. Brower, please proceed.
Good morning, Justices of the Supreme Court.
You might want to pull the mic up a little bit there. How's that?
Is that better?
Yeah, give it a try. Let's see. Yeah, please go ahead.
All right. The Hawaii State Legislature had passed a law, it being Hawaii Revised Statute 657-1.8A. The statute essentially allowed for the bringing of claims or causes of action for minors who alleged that they were sexually abused. It essentially extended the statute of limitations. Now, we don't have a problem with the extension of the statute of limitation. What we do have a problem with is the section of the statute which indicates that the cause of action shall, in quotes, shall be based upon sexual acts that constituted or would have constituted a criminal offense under Part 5 or 6 of Chapter 707. The problem with the statute is that it applies criminal laws presently that were not in effect in 1975 and 1976 when the alleged acts of sexual abuse took place.
Well, counsel, why can't you read the statute as allowing for consideration of offenses that were in place at the time the acts occurred? Why do you read that possibility out of this statute?
Well, I don't have a problem with the criminal law that was in place or in effect in 1975 and 1976, but that's not what was done in this case based upon the plain reading of the statute. The trial judge indicated, and I agreed with the trial judge with regard to the plain reading of the statute, i.e., we must take the present criminal law and we must act as if it was in place in 1975-76, and therefore the jury, the fact finder, must make its decision whether or not there are facts that support the claim based upon criminal laws that were not in place in 1975 and 76.
Well, how do you get that plain reading, though? It doesn't say based on laws at the time this civil action is brought. I mean, that's essentially what the circuit court's reasoning was, but that's not in the statute. What is it about either the plain reading or legislative history of this statute and this particular provision that, in your view, requires application of current criminal offenses at the time the tort suit is filed?
I think the focus was on the use of the words or would have constituted or would have constituted. The statute doesn't say apply the criminal laws that were in effect at the time of the alleged incidents. It says acts that constituted or would have constituted criminal offense under, we interpret as present.
And you don't read that as possibly including the offenses that were on the books in 75 and 76?
No, and the reason I don't is because I believe the legislature and the persons that were instrumental in creating the law decided that it would be easier to apply the present law, because simply what you would do is you take out the present criminal penal statute, and then you could use that readily. One can imagine the difficulty in having to go back to 1975, 76 and find the law that was in effect at that time.
Why is
Why-
that difficult? To find the laws that were in effect in 75 and 76? It's not that difficult.
Well, it's more difficult than just using the current, version of the penal code.
I'm sorry?
It would be more difficult than using the current version of the penal code.
Because it would require going to the law library.
Excuse me?
Because it would require going to the law library instead of searching for it online.
I think that might be one reason.
Would you have a I'm so sorry, go
Oh,
ahead.
CJ, go ahead.
Would you have a problem if the statute had simply said may bring any action in tort for the actions taken by the defendant, including, for example, intentional infliction of emotional distress? Would you have a problem with that?
Absolutely not. The problem that I have, again, is that the civil statute, and I've reviewed as many cases as I could find with regard to this situation, and there's not a case where a civil statute basically extracts criminal law and embeds it into the statute. That's the problem I have.
In a way, doesn't that advantage your client? Because it puts additional roadblocks in the way of the plaintiff. In fact, rather than just going in and saying, hey, this was a horrific act that the defendant should have known was going to cause grave emotional distress to my client, the plaintiff has to go through and prove the elements of one of these offenses. So how does that disadvantage your client in a way that suggests this is an invocation of penal liability and should be stricken as ex post facto?
Well, I see the disadvantage as essentially violating his constitutional rights, i.e. Making a criminal law apply ex post facto. I mean, it's very clear in the Constitution, the United States Constitution, that a state is prohibited from doing that under Article 1.
But that applies only if, in fact, your reading of the statute is right. In other words, if you are applying present laws to conduct back in the 70s, which didn't exist at that time. That's when the ex post facto issues come in, right?
Right, yeah, I would agree.
If the offenses that were in place in 1975 and 76 were applied under this statute, we wouldn't have an ex post facto issue.
Correct.
All right.
And the law that was applied, again, was statutes that exist now that when you go back in time in 1975 to 1976, they were not, it was not conduct that constituted a criminal offense at all. I mean, and so that's
Is
where
that
the-
true?
Yeah.
Go ahead.
Aren't they? Well, first of all, there was indecent exposure. But what about sex assault third? I believe back at that time, sex assault third would cover conduct. I'm sorry, sex assault first. Intentionally had sexual contact with another person who's less than 14 years old or causes such a person to have sexual contact with him. There was 707, 736, sex abuse first degree. Very, very similar to our current statute. And could we not find that the instruction on the current statute for this offense or for indecent exposure, why wouldn't that be harmless if, to the extent that there's a substantial overlap between the current statute and the past statute?
Because when I looked at the current statute and tried to match it up with what seemed to be similar, the statute in 75, 76 was actually entitled rape first degree. And that statute talked about basically sexual intercourse with a female.
You're citing to a different statute. The one that Chief Justice cited to is 707-736. I thought you cited to 707-737, was it?
707-730.
707-730. But did you, he's citing to, Chief Justice is citing to 707-736.
36, yeah. All right, well, notwithstanding all of these different criminal statutes were read to the jury that they must apply to decide whether or not the claim exists.
You know, the jury found in their special verdict or their interrogatory or whatever it was that your client committed sexual abuse. And I do see sexual abuse in the first degree and indecent exposure back then as being similar to now. So back then a crime, now a crime. What's the harm in the jury instructions here? If it was a crime then, it's a crime now. Isn't it harmless?
Well, not all of the instructions matched up, though. I mean, there was instructions given for present law that didn't equate to what the law was back then in terms of the acts that constituted the crime.
Are you referring to continuous sexual conduct, for example?
Yeah.
Okay, but does that, again, you know, the jury's looking at things, they're making one finding that your client's liable for a tort, and then it's affixing damages. I mean, are we really arguing here about liability, or somehow damages were impacted by the injection of new crimes that weren't crimes back then?
Basically arguing that, you know, this ex post facto law, constitutional right, was abridged by taking laws that exist now and making them as if they existed back then.
And you know, and I understand the Calder Bill, 1799, and all that. But assuming we don't go along with your ex post facto, is there really a big deal between new crime, old crime, and the fact that the jury basically found your client guilty of a tort?
I mean, I would say that there's a tie-in between the type of criminal statute that you apply and the damages that someone is subject to in terms of being found responsible for.
Well, the damages had nothing to do with the crime being charged, right? Damages is based on the plaintiff's evidence of emotional distress and so on. That's what the damages was based on, right? There was no physical injury. It was emotional, mental.
Well, I mean, we don't know exactly how the jury decided in terms
Well,
of
what do you think it was based on?
the damages.
Yes, it was general 50, you had 200 in punitives. What do you think the 50,000 was based on?
Well, this is outside of the record, but the respondent had requested that the petitioner pay him, it was about $250,000 that he was about to inherit from his mother. And
No, based on the evidence that was
in the
presented,
court,
what was the evidence? It was basically emotional distress, mental distress.
yeah, 50 in general damages and then 200 in punitive damages, punishing damages.
Right. So the damages weren't based on the type of crime, the jury instruction, right?
Right.
Okay. And given your client's admissions, the email and everything else that has been admitted to, there was substantial evidence that 707, 736, as it was written back then, was violated. Isn't that a fair statement?
It's hard to say just because we don't know how the jury came down in terms of its decision.
No, I'm asking you.
Do I think?
Based on 707, 736 that the Chief Justice read, that statute that was in existence at that time, and your client's admissions, there was a clear violation, was it not?
I don't think there was. I mean,
Well, why do you think there wasn't?
why do I?
Yeah,
think there
based on
was
what your
not?
client,
Just based on the evidence and based on my belief in what my client said.
well, in your filings, you say that your client admitted to doing what he did in front of this child.
Yeah, I mean,
And he admitted to it in the email.
that would not be a continuous course of conduct. That's one incident. One incident on one day at one time.
I thought the email said 3, 4, maybe 5 times.
That may be
Well, I
correct.
guess we'll refer to it.
But I mean, either way, I mean, there's all these crimes out there that the court gives for the jury to consider to, I guess, flavor what sexual abuse is. And we obviously don't know what their calculus was. But we do know what their calculus was in the sense that they did find liability for a tort. And I guess I'm just wondering why, in your view, does it matter if you have a crime back then, that it's a crime now, just with different wording, why it should even matter? I mean, why, again, can you tell me how that's not harmless?
Well, I mean, I never consider it harmless. If there's a violation of someone's constitutional right, it clearly is not harmless.
Okay, so that's the ex post facto argument?
Yes.
Okay, other than the ex post facto argument, is there anything harmless about what transpired?
That would be the problem.
Thank you.
How is it ex post facto if the criminal offense was defined essentially the same way in 76 as it is now for 707, 736, sexual abuse in the first degree, intentionally has sexual contact with another person who's less than 14 years old or causes such person to have sexual contact with him. And the wording of our current statute is quite similar. So how is it even an ex post facto issue?
Well, for example, the assault in the second degree. First of all, talking about with a female, that was not the facts here. The statute has changed. Strike that. The 75-76 talked about sex with a female. The statute now doesn't make any differentiation between male and female. In addition, 707, 734, there was a requirement back then that there be an intent to arouse sexual desire.
But Mr. Brower, you keep referring to these statutes, and I agree, those statutes did refer to male and female. But you seem to be ignoring 707, 736, and 707, 737 that were in effect at that time, which talked about sex abuse, and it's sexual abuse. And the jury instruction talked about sexual abuse, right? Sexual contact with another person who is less than 14 years old or causes such a person to have sexual contact with him. Why, based on your client's emails in which he admitted to sexual contact under this definition, why is this not harmless?
Well, again, I fall back on the constitutional right issue. The application of laws that are in effect now to be in effect back in 75, 76.
These are laws that were in effect. You haven't cited the applicable law. We're discussing 707, 736, and 737, which made these crimes back then. You're only citing to other states statutes talking about rape, of a man against a woman, but there were statutes on the books that that criminalized the very conduct that your client admitted to.
Yes, but I submit that the ex post facto clause, it flatly prohibits retroactive application of penal legislation. That's Bank versus Markazi.
But it wouldn't be retroactive because it was on the books at the time, in the 70s. It's not retroactive.
Well, again, I don't believe that the statutes were the same. I believe that there was different,
They're very close.
well, there was different acts to constitute the crime in 75, 76 as compared to now. So that's really where the violation occurs, because you're taking a present criminal statute, you're telling the jury, you must apply this statute as if it was in effect. And again, you
No,
get
I understand that part, but you're not answering the harmless error part of the question. And let me ask you, did you move to strike or dismiss the claims based on assault, battery, or emotional distress?
no.
Okay, so you understood that those claims arose out of the sexual abuse allegations?
Yes.
As part and parcel of that claim?
That's right.
You didn't have any issues with that?
No. And in fact, you know, the whole thing could have been done differently if the legislature had not applied the criminal law to this. I mean, you know, so sexual abuse essentially can be defined as an assault, and all of the elements of an assault that somebody would find in tort law is applicable. There was really no need to instruct the jury on the criminal statute, and that's where they got into trouble, I believe, because again, if you take a law and you say you're going to apply this as if it was in existence at that time, that's an ex post facto violation. And, you know, that's the whole purpose of the ex post facto law, because we want individuals to, excuse me. We want individuals to understand what it is that if they do, they're subject to being punished. And so these laws, because they were not in effect back in 75, 76, the petitioner had no idea that what he was doing was a criminal offense because it didn't exist at that time. So that's another problem with it being a due process failure to give notice of what acts constituted a crime. So I submit that the very application of current law to the law back then is a constitutional violation, and that a constitutional violation of one's right is never harmless. You can't not harm someone if you're going to violate their constitutional rights.
Okay, counsel, one more time, if I could ask you this, I'll ask you this way. If in fact the circuit court had instructed the jury only on the criminal offenses that were in place in 1975 and 1976 in the jury instructions, would that be problematic in your view?
No.
All right, so that's the problem. That's the key to the problem as you see it, because otherwise there's no ex post facto issue. You already said that. And so why are you, the question that you are being asked though is, if that's the case and you see no problem with that, if what they actually were instructed on are crimes that in place at the time the tort suit was filed are very similar, what's the difference between the statutes that you find problematic?
All right, well, with regard to 707, 730, sexual assault in the first degree, the current statute says defendant did knowingly and plaintiff had sexual penetration, and the defendant did so knowingly, and the plaintiff was less than 14 years old at the time of the incident.
Well,
That's the current statute.
Right.
Yeah, and you know, this was two males, minors. The 1975-76 statute on 707 7:30. I had it as a male had to engage in sexual intercourse with a female by forcible compulsion.
I think the reference in the past inquiries with you has been with regards to sex assault in the third degree, which
Okay,
speaks
all
to
right, and then-
sexual contact,
Yeah,
not penetration.
let's see.
And, I mean, if you can address it in rebuttal, but that's the question that you're being asked.
Okay.
Anything else at this time, Mr. Brower? Or do you want to reserve?
Can I
Oh,
ask one more? I'm sorry,
Please, Justice
Chief
Evans.
if I may. The 707, 736, read in part at the time, one would be in violation if he intentionally has sexual contact with another person who is less than 14 years old or causes such a person to have sexual contact with him. That's how it read in part at the time, 75, 76. And then we have the email that's in evidence from your client to his brother, who says he did things with him there, and yeah, I asked him to help a little, and he did. That's what your client admitted to. So would you agree he was in violation of the statute as it was in place at the time back in the 70s? Didn't he basically admit that he committed that offense?
Well, I believe he had a different explanation at the time of the trial.
He says, I did jack off with him there, and yeah, I asked him to help a little, and he did. I would guesstimate 3, 4, maybe 5 times.
Yeah.
That was his words, wasn't it?
Well, that was what his brother had as a piece of evidence. But in his testimony at the trial, that was different than what that statement was.
But there was no challenge to the authenticity of the email, as I understood.
No, I mean, it went into evidence. Yeah, there was no challenge on the authenticity. Just one more thing. This United States versus Ward 448 U.S. 242, it talks about the Mendoza case, and it says that that list is not exhaustive and it's not dispositive. So in other words, the Court of Appeals made this analysis using the Mendoza case. There was 7 things that it looked at. It said the respondent won on 4, we lost on 3. But under this United States versus Ward case, it says that the list in Mendoza is not dispositive, and it's not exhaustive. And I submit the very application of current criminal laws to an incident that took place back in 75, 76 is an absolute violation of the United States Constitution and should be a violation of the state constitution, i.e. the state constitution that adopts the United States Constitution. And so based on that, and based on the case law essentially indicating that there is a flat prohibition against retroactive application, that's in the Bank Markazi case, U.S. Supreme Court, and also Landreth versus USI Film Products. It also says, quote, the ex post facto clause flatly prohibits retroactive application of penal legislation. So based upon that, I would submit that the lower court decision should be reversed.
All right. Thank you, Mr. Brower. Mr. Arensmeyer.
Good morning, Your Honors. Before I get to the merits, there's a preliminary procedural issue that I'd like to address. I was not involved with the briefing of this appeal, but I did review the record, and it does not appear that notice was given to the Attorney General of a challenge to the constitutionality of the underlying statute. Any party challenging constitutionality is required to give notice to the Attorney General under Appellate Rule 44. And the Attorney General then under Rule 28G has a right to file an amicus brief without leave of court. It appears that the Attorney General may not have been notified in this case. So if this court is at all inclined to find this statute unconstitutional, I think steps need to be taken in order to notify the Attorney General and give them an opportunity to be heard from.
Thank you for bringing it to the court's attention, Mr. President.
Next, on the merits, if we start and we look at what was claimed in this complaint, there were 3 claims: sexual assault, intentional infliction of emotional distress, assault, and battery. All 3 of those were torts back in 1976. There was no claim, there was no cause of action that arose in this case under Section 657-1.8. And in fact, that statute is a limiting statute. Application of that statute actually favors defendants. It appears to preclude certain claims, such as claims founded in negligence, because it requires acts that would have amounted to crimes. Those acts require intent, so seemingly it precludes a number of potential claims. In addition, it requires plaintiffs to obtain a certificate of merit. That's a further protection in favor of defendants from potential false or frivolous claims. The real question here, well, what the ICA did is they employed a 2-part test. It's called the intent effects test, and it arises from the Mendoza-Martinez decision many years ago, which was revisited by the U.S. Supreme Court in Smith versus Doe, and then also the Ninth Circuit in Russell versus Gregory.
Can I just interrupt you on one point? So we get to, before we get to the test, how do you interpret this statute? What is your reading of this statute and what it authorizes the court, or what it requires the court to do in instructing the jury, or what it makes subject to the tort?
Thank you. To the extent that the statute contains the language, acts that constituted or would have constituted a criminal offense, a plain reading of the statute would suggest that you could apply the criminal code as it exists today or back then. I don't think it matters one way or the other. It is probably more convenient to apply the existing criminal code, but again, this statute wasn't intended to create new offenses. It was intended to limit offenses.
Mr. Arnsmeyer, on
Yes.
that, okay, you mentioned the claims that are asserted: sex assault, IAED, sexual battery. Is it your contention that those claims could have been brought regardless of this statute? It's only because of this statute that extended the statute of limitations that allowed your client to bring the claims, right?
Well, I would submit that those claims existed. It's a question of when they could have been brought.
Yes,
They
that's the
existed.
question.
The law didn't establish, the statute didn't establish those claims. It only extended the statute of limitations. And in fact, the petitioner admitted in their opening that they don't have a problem with an extension of the statute of limitations.
So my question though is, do you think, is there some timeline that, you're saying you think these particular claims could have been brought in this case when it was, except for this statute, if this statute didn't exist?
Oh, sure. Typically, a tort claim is brought within 2 years.
Right.
But the problem that the legislature saw is that we're dealing with children who are often abused by family members. They don't have access to attorneys. The people they rely on to protect them are their own family, who are often
So this
their
statute
abusers.
allowed an extended limitations period beyond the typical 2-year tort statute of limitations, right?
It did, and it
Yeah.
extended civil liability under tort claims. It did
Well,
not
it says civil cause of action for sex abuse of a minor. I mean, that's what 657-1.8 says, a civil cause of action for the sexual abuse of a minor.
That's right. So, for example, intentional infliction of emotional distress. The facts that give rise to that tort claim have to match up with one of these criminal statutes. For example, the client could not have brought a claim under this statute for negligent infliction of emotional distress because none of the criminal statutes would have involved acts of negligence. All of these torts existed. There was a certain statute of limitations under the law. The legislature saw fit for good sound reason to extend that statute of limitation in very limited circumstances and for a very limited group of people.
Nobody's arguing about that. The question is how you read this statute and what criminal laws, if any, needed to be instructed to the jury.
I don't have a preference one way or the other. It could have been the present or it could have been the past. There's still not an ex post facto problem.
Well, let me
here.
ask you this, does it have to be either? I mean, if this is a statute of limitations law that it's limiting, as you say, I mean, is there even, and it boils down to, all right, I'm in the game. Your client's in the game based on our law, based on 657 1.8. But then from there, it's just a tort action. Do we even need to inject criminal law then or now into a case?
Well, to the extent that the petitioner is arguing that the law is somehow punitive in nature.
Aside from that,
Okay.
aside from the ex post facto and argument, in these types of tort actions under 657 1.8, where there's a statute of limitations, your client from 1975, he was a youth, can now get into court, level his tort claims, and try to prove intentional infliction of emotional distress. Is there a need to even have the jury instructed on criminal laws from 75 or now?
Well, it appears that in order to extend the statute of limitations, if we're in a situation where, we're past the original 2 years, then yes, I think this statute does limit which claims can be brought. But does it matter whether it was based on criminal conduct as it was written then or now? I don't see a difference.
Okay, but I'm talking about then once we get in and we were sitting in front of a jury and the court's going to instruct the jury and how to guide them to reach, is there an intentional infliction of emotional distress? And if there is, how much money is involved? My question is, do we need the criminal law?
I'm not sure, Your Honor. Perhaps you don't. Perhaps that's a question of law for the judge and not a question for the jury.
Well, can I ask you, so what happens at trial? Are you proving the elements of the crime, gratification, and everything else that's involved with those criminal statutes?
Well, it appears that in this case, that's what happened. That's what the jury was
No, but is that what you're supposed, is that your burden to prove all the criminal elements? Was what happens if you can't prove gratification, but you can prove intentional infliction of emotional distress? Because that doesn't involve gratification, but you prove that, do you lose?
Well, again, the statute says acts that constituted or would have constituted a crime. So if they would not have constituted a crime, I think your claim is precluded under this statute.
So if you can't prove gratification, then you lose, even though you can prove infliction?
Well, I think you've got to establish one of the list of various crimes in part 5 and 6 of 708.
So you're taking the position that you would have to prove every criminal element, mens rea, everything, in order to prove your claim?
Well, I mean,
Because you also said that 657 1.8 isn't creating a new claim, and I agree with that. It's just opening the statute of limitations for these types of cases.
The statute, it uses the language constituted or would have constituted a criminal offense. So,
But it also says shall be based upon, that civil action shall be based upon those types of cases.
I hear where you're coming from. Based upon, that's a difficult question. I don't think it matters in this case as far as the question of whether this statute is unconstitutional as ex post facto. The statute clearly,
Well, Mr. Brower's already conceded, if the judge had simply read the criminal statute that was in place at the time of the act, that resolves that issue. But I'm more concerned about what is it that the complaining witness has to prove under this statute? Criminal elements? It's a civil action.
well, there's a big difference between a criminal and a civil case as far as the burden of proof. So, in a civil
Okay, that
case,
aside.
you're dealing with a preponderance of the evidence.
If you're
In order to
proving-
prove a crime, you've got to show clear and
but
convincing
is it
evidence. So to that extent, I would agree with you that no, in a civil case, you're showing a preponderance of the evidence.
I'm not talking about proofs. I'm talking about, is 657 1.8 creating a new claim? Because if you got to prove elements of a crime, isn't that a new claim?
No, it's not. It limits the claims that the legislature is allowing you to extend.
By proving a criminal violation?
By tying it
That's
to,
a civil action?
by tying it to what could have been a criminal charge.
Well, most civil actions, we don't have to prove a criminal violation.
Right.
Where's
Right.
it flow?
I'm sorry.
I'm sorry.
The statute doesn't say it has to be based on having committed a crime. It says a civil cause of action for the sexual abuse of a minor shall be based upon sexual acts that constituted or would have constituted a criminal offense. So it seems like it's only referring to the acts, not to the mens rea. And this is a statute of limitations statute. And I'm wondering why you are conceding that you couldn't get NIED or negligence claim arising out of the sexual acts that would have constituted a crime, because I'm thinking of Doe versus Norton, where a teacher is sexually molesting students. And the underlying claim, the intentional acts were the claims against the defendant were actually dismissed because of bankruptcy, but it was the Department of Education that was on the hook for negligent supervision. Or, why wouldn't you be able to sue, parents that knew that their child, that knew that someone in one of their adult children was a sexual molester, and had kids over all the time and was sleeping with kids in their room? Why wouldn't another entity have potentially respondeat superior liability arising out of the sexual acts based on a negligence theory?
Perhaps they would, and the statute does carve out a provision where you can sue an entity. Obviously, an entity doesn't commit one of those crimes in Chapter 707, but it would be based upon those
Right.
acts.
Can an entity commit an intentional tort of this nature?
Right.
Wouldn't it be respondeat superior liability?
Right, but perhaps a negligence claim could be brought against an entity based upon acts committed by someone else that would have constituted a crime. I would
Or
see that.
negligent supervision or training or.
Sure, I would see that
areas like
within the
that.
scope of the
And
statute.
why wouldn't someone be able to sue for NIED based on the sexual abuse that occurred to them when they were a child?
Again, I think it depends on the nature of the claim and who you're suing. If you're suing the actor, it might be a different test.
Mr. Arnsmeyer, it seems like both parties here treated it as if it was a claim. There was such a thing as a claim for sexual abuse, which had been established by the statute, though, right? That's the way I read it. And where I'm getting that from is a jury instruction where it says, plaintiff claims defendant is liable to him for sexual abuse of a minor. To establish this claim, the plaintiff must prove by a preponderance of the evidence the following elements. So seems like this, it was, both sides seemed to agree that there was a claim, and that related to sexual abuse. I'm not sure there was a tort of sexual abuse so
There's,
named back in 1975.
there's no tort of sexual abuse, but there was a tort claim in this case of sexual assault, which absolutely was a tort back in 1975.
One interesting thing to me is the court instructed the jury on intentional infliction of emotional distress, and it didn't really seem to link it in any way to the asserted claim of sexual abuse. What do you make of that? Was that error for the court to instruct the jury in that manner?
I wouldn't think so. As long as the jury found that there was sexual abuse, it could then proceed to deliberate on the elements of the underlying tort.
You think they had to? In other words, you don't think the jury could simply have decided that there was intentional exposure, not married? Oh, I'm sorry, that the elements of the defined tort of sexual abuse had been met?
Well, if
You
those,
think they had to then go to intentional infliction?
but not to the extent that those elements overlap. But if there was anything further that needed to be established, then yes.
All right, thank you.
Counsel, let me ask you if I may. How would the outcome of the trial differ in your view, if the criminal statute in effect at the time the act occurred was read as a jury instruction? How do you think that would have changed the outcome, if at all?
I don't think it would change the outcome. But
Why do you say that?
you know, that would be a call for the jury. There would have been a finding of sexual abuse either way. The jury could have pointed to a statute in existence at the time that was violated. The facts of this record show that, and to the extent that the jury may not have been instructed, so any error would be harmless. Whether we take, offenses then or offenses now, the fact established by this evidence prove establish sufficient violation to then adjudicate these tort
And do you
claims.
think that jury instruction would have changed the damages?
No.
Well, but, the jury is figuring out generals and punitives, and they look at all these new crimes, continuous sexual assault of a minor, all these things that really weren't offenses back then. They go, holy cow. I mean, couldn't that affect the damages in this case?
Whether or not a crime is committed isn't really tied to the damages, emotional distress, or injury that someone hurts, just simply because certain tortious acts are also defined as a crime. I don't think it would matter.
Mr. Arnsmeyer, the instructions that were actually given included a definition for sexual contact. And sexual contact was one of the elements under sex assault third in the jury instructions given in this case. It seems to me, and I think this was argued in the briefs, although I haven't heard it argued today, that the definition of sexual contact under the current statute is different than the definition of sexual contact back in the 70s. And that includes an intent of gratifying the sexual desire of either party. And that was in the briefs. I remember seeing it. But so isn't there a difference in terms of what the law is or was when this lawsuit was filed and the offenses that in fact existed back when this conduct occurred in 75 and 76?
Well, again, I would go back to the point that the evidence on this record would still establish those elements. I believe in the briefs it addressed the issue of masturbation and that, inherently being gratification.
I guess the question then is, should we step into the role of the jury to make these determinations?
I don't think an appellate court should ever step into the role
Right.
of a jury. It's a question of law. Was the jury correctly instructed?
Right. Was the jury correctly instructed? Because there's more than just that. I mean, as Justice Edens points out, there's all kinds of other offenses that were instructed upon that weren't in existence in 75 or 76, right? So if a jury is instructed on the law that existed at the time, I know you say it doesn't matter which version is instructed. You think it's okay either way. But so if they were though instructed based on the law in 75 and 76, you see no problem with that going forward with the jury.
I don't see a difference. Again, I'm not one of the jurors. Anything in the world could affect a juror, but as an outsider looking at this, I would suggest that any alleged error in the instruction was harmless because the facts that the jury found would have established a violation under either version, either currently or past.
But the only fact that they found, I guess maybe there's two. There were only two on the liability side liability side is, did the defendant commit sexual abuse of a minor? I mean, that's the only real fact that they found, right, under the special verdict form.
Sure.
But those instructions go to that question of what is sexual abuse of a minor.
They do. But I don't think you can, even if you apply those instructions to the law as it existed back then, gratification is still established on this record. It doesn't make a difference as a matter of law. As a judge instructing the jury, you're instructing as to the law, not the facts. Anyway, I had intended to go through the 7 factors today and talk about the intent effects test. I think we've really addressed most of that. And however, just to summarize, the first question under that test was this a criminal statute? Well, clearly it wasn't. Then the court looks to, well, what's the nature and the application of it? Well, here it's to extend a statute of limitation. So it's not a criminal statute. So then you go to the next step. Is any punitive effect of this statute excessive, or does it outweigh the legislature's intent? And in this case, the legislature's intent, again, was to give access to children to pursue liability, knowing that, many times they otherwise can't. And I think the most instructive case is the Smith versus Doe, the U.S. Supreme Court case, as well as this court's case in Urity. And it ultimately comes down to balancing. In this case, was this statute punitive? Well, yeah, you can always argue that holding someone liable for committing a civil tort is punitive, especially when they're awarded punitive damages, but that's not criminal punishment, that's civil punishment. And again, it's a balance. Here, I think that some of the most important factors that the court should consider are, again, the fact that this statute potentially limits the kinds of claims. They've got to arise from acts that would be crimes. That potentially, doesn't include all the claims that could be given, and more importantly, it requires that these victims, before they sue, that they go to a therapist, that someone evaluate them, and that then a certificate of merit is established in this case. I think that this statute overwhelmingly provides protections for the wrongfully accused, while also, extending the ability for minors to pursue liability.
Mr. Arnsmeyer, the statute, again, the part we're talking about, says a civil cause of action for the sexual abuse of a victim when the victim was a minor shall be based upon sexual acts that constituted or would have constituted a criminal offense under Part 5 or Part 6 of Chapter 707. What would happen if the sexual acts were alleged to have occurred prior to the adoption of the penal code, say in 1968? Plaintiff's out of luck? Or would the plaintiff have a claim because the question would be whether that conduct would have constituted an offense under current law?
Well, I think they'd still have a claim, as long as you can show that it would have constituted a claim. That's what the statute says.
Under current law?
Current or prior. If it didn't
Well, at the
exist
time,
prior,
it didn't exist.
if it didn't exist prior, then it appears the statute on its face says then you apply current law. if it would have constituted, if those acts would have constituted a crime.
Under current laws of the date of the offense, or date of the complaint.
Date of the complaint.
And your position, the argument you were just making, is that that is not an ex post facto issue problem.
That's not, because that's not criminal punishment. That serves a civil purpose. It provides access to justice for abused minors. It in no way creates a criminal record or imprisons somebody or publicly humiliates someone for the purpose of punishment. It simply extends a victim's ability to recover financially for their damages.
What if the prior law said that the sexual assault of a minor was under the age of 16 rather than the age of 14? Are you saying that a 15-year-old at the time would have a claim even though it wasn't a crime then?
Yes, yeah. I believe under a plain reading of the statute, and I believe the reading that the judge actually employed in this case, yeah, if it would have under current law, then yes, you can bring a tort
How
claim
is that
at
not
this
ex
time.
post facto?
Well, again, it's because what does the law do? It doesn't create a criminal record, doesn't put someone in prison if they're found to have committed a tort. It's simply not punitive in the historical sense that criminal laws are punished. It's purely civil liability to victims.
And you know, here's a I guess a real live example of a prior acts that might not have been a crime but are a crime now. There was a Mueller case in 2003, and that was the case in which this court said the prosecutors are required to prove some penetration, no matter how slight, to convict a defendant of first degree sexual assault. So Mueller's case got reversed. Subsequent to the legislature change, and that overruled a case called Rulona. Then the legislature kind of quickly moved to change the law to revise it. But what you're saying, if I get it correct, is the victim in Mueller, although it wasn't a crime then, because this court required penetration, would have a cause of action now.
Yes. That's right.
And again, it's the time of the complaint that's relevant.
That's right. That's right. I see that I'm almost out of time, and I do want to go back to this, this 7-factor test that's established by this court and it's established by the U.S. Supreme Court. And at the end of the day, it creates an incredibly high burden for the party challenging the law. It requires the clearest proof that the punitive effects of the law outweigh the legislature's purpose. This appellant, this petitioner, certainly has not met that burden in this case. The ICA was correct to observe that, and for that reason, I would ask that this court affirm the ICA.
Very well. Anything further at this time?
No, Your Honor.
All right. Thank you, Mr. Arnsmeyer. Mr. Brower, your rebuttal.
Well, again, Your Honors, I focus in on the particular case here where the legislature took a criminal statute and required that it be applied to incidents that took place back in 75, 76. I don't think that there's any case that can be found where such a thing has occurred, i.e. taking a criminal statute and making it applicable to something in the past. It just screams out ex post facto violation. There was absolutely no need for the legislature to have done this. There was no need bring in the criminal law for essentially what amounted to torts.
What's your response to Mr. Arnsmeyer's argument that this benefits the defendant because it narrows the causes of action that can be brought? It sets a high bar. We're not just anything that someone might say, hey, I suffered emotional distress and I should be able to argue that to the jury. You have to show conduct that would have constituted or would have constituted a criminal offense. And that's actually narrows the range of liability. What's your answer to that?
Well, just the reading of the statute to the jury, as the justice had indicated, that could very well be highly prejudicial because they're listening to criminal statutes, criminal acts and offenses, and then using that to be inflamed by the case before it.
Very well. Other arguments that you wanted to raise?
Just reiterating in the Mendoza case that the United States versus Ward said it's a list that's not dispositive. And because we have a situation that I don't think is replicated anywhere in any state or United States with regard to a statute saying you are required to apply the criminal law in this fashion to make up the claim. I think that ex post facto fact just is a factor that should be considered, and that because the Mendoza list is based upon certain situations where nobody's taken a criminal statute and said you shall apply this, for acts that occurred in the past. It's so unique that I asked the court to consider with regard to our position that it's an unconstitutional statute. And based on that, Mr. FORESMAN's his constitutional rights were violated, and therefore the statute should be so declared, and that there be a reversal of the decision.
Could we not remand for a new trial with a direction to instruct the jury on the then current offense? Isn't it possible for us to read the statute as to avoid the constitutional problem, read it as requiring that the jury be instructed on the then current law? So that would be a new trial as opposed to invalidating the statute. What's your take on that?
Yes, Your Honor, that's a possibility.
All right, very well. Anything further for the court?
Nothing further. Thank you for your time.
All right, thank you to both of our attorneys today. The court will take this matter under advisement.
Eku Iluna, please rise. Ua ho'o malolo ia mai nei kia aha ho'o kolo ki ike hana hana. This Honorable Supreme Court is now in recess.